All right. We'll go ahead and get started. I have a decent amount to cover today. I am Todd Hefner. I'm a partner here at Smith Gambrell and Russell, part of the leadership of the Georgia Bar Construction section and the Atlanta Bar Construction section. Before we dive into today's content, wanted to mention very briefly some of the upcoming sessions that we have on January 22nd. We'll have, and all of these are at noon and virtual, just like the series is. On January 22nd, Introduction to Construction Contracts and Subcontracts. You should already have that one in your email inbox and the ability to register. On January 27th, we'll have Introduction to Changes, Differing Site Conditions, and Key Risk Shifting Provisions. You should see in relatively short order the invite and registration link for that. And then coming up on February 10th, we have different project delivery methods and pricing arrangements. Beyond those three, I think we still have another 5 or so, if not more, of these Construction 101 sessions. So you'll just see those coming throughout the year. In total, we're planning 15, and I've forgotten how many we've done so far. All right. Today's session, working with experts, going to present this along with my colleague, Wheaton Webb. I'm going to cover maybe the first half and talk about a smorgasbord of a lot of different topics. And then Wheaton is going to cover Daubert. Wheaton is a former federal clerk and has far more experience with Daubert challenges than I do. He spent a couple of years in a more general commercial litigation role where he encountered a lot of medical experts and a lot more Daubert challenges in that space than you often find in the construction space. And we'll cover some more on that later. But Wheaton, as I mentioned, federal clerk, formerly, and one of my colleagues here at Smith Gambrell and Russell. So Wheaton, thanks for being voluntold to do this with me.
You to participate.
All right. Yeah, and I got 30 less minutes that I had to prepare as a result. All right. Today we're going to cover the basics of working with experts, common expert types for construction disputes, how you can think about selecting and working with experts, the concept of testifying versus consulting experts, some privilege considerations, a couple other topics, and as I mentioned, Wheaton's going to cover Daubert with the second half of this. Okay. This is Construction Law 101, so we're going to start really basic. Why are experts even necessary in the first place? It's as simple as the federal, or at least at the federal level and, state analogs, the evidence rules do not allow fact witnesses to provide opinion-based testimony. If you want opinion-based testimony outside of certain exceptions, you're going to need an expert. So at a super basic level, you need experts to give opinions. Obviously, as the name implies, experts should have a certain level of expertise that they are providing. They're obviously necessary to provide that. And we'll cover kind of what areas you often encounter, but obviously, an expert's going to provide probably a detailed scientific opinion or technical opinion of some sort. Experts theoretically are independent. I say theoretically because it's always miraculous how the experts hired by each side testify in a way that is favorable to the side that they are hired by. But there is a certain amount of independence associated with each expert that is supposed to make their testimony slightly more credible than it would be otherwise. They're being retained separately. You can retain a expert or use an expert rather. You wouldn't retain them from your own client, but that's kind of the exception, not the norm. All right. The timing of hiring experts. Generally speaking, the sooner the better you hire an expert. You want to get them in as early as you can on your cases. On a lot of cases, they're going to drive many aspects of the case, what discovery is necessary, what even are some of the relevant facts to consider, that sort of thing. In a highly technical case, an expert might suggest that you do certain testing throughout the discovery phase. And if you don't have your expert hired early, you're going to be behind the eight ball when discovery is ongoing and getting towards the end. If you don't have your expert engaged early, you might even need them at the claim development phase. That said, and this kind of blends in with the next bullet of procedure, experts in terms of just where they fit into the case generally come after all the fact depositions. You'll go through all the fact depositions, and then experts often will consider all of the fact testimony that's been given, so they need a little bit of time to incorporate that into their report, and then experts provide their reports at that point. The one thing I will say about timing is, in my years of practicing, I feel like a lot of people think experts only proceed in a certain way or the timing is a certain way. It really varies a lot based on court and jurisdiction and personal preference. I've been in some areas when I was practicing or had a case rather in Oklahoma. Even though we're theoretically proceeding under the same federal rules of civil procedure there that I would in Atlanta, the way we handled experts in Oklahoma were way different. So it's really important for the timing and procedures with your experts that you read the applicable rules, so federal rules of civil procedure, Georgia rules of procedure, what have you. And you know those, you read any local orders and any standing orders from your judge because they will all differ, or there's a very good chance that they will be very different. I even heard of a case recently where another side was so used to practicing in state court where they were not required in state court to disclose their expert automatically in the jurisdiction that they were practicing in. And typically in that state's jurisdiction, parties were then smart enough to serve an interrogatory that required disclosure of the expert. The other side thought that they had pulled a fast one on the other side. They weren't served an interrogatory asking them to disclose their expert. And because they failed to follow their obligations under Federal Rule of Civil Procedure 26, they didn't disclose their expert, and it was a huge problem. So I was kind of incredulous, but this was coming from a federal magistrate judge who then strongly encouraged the parties to settle their case, which they did. So it's really important that you know your rules regarding expert disclosure obligations wherever you may be. The applicable rules I've kind of mentioned throughout already a little bit, but obviously you have the federal rules of evidence, the 700 series, basically 701, 702 kind of establish that baseline of why they're necessary and what they can testify to. Federal Rule of Civil Procedure 26 has your disclosure obligations. The Georgia version under the Civil Practice Act, so OCGA 91126, is going to drive a lot of the expert obligations there. And then generally speaking, arbitration rules are going to be completely silent on experts and how they are used. So it is generally through mutual agreement in our arbitration cases that we agree to an expert disclosure schedule and what the obligations are there. All right. Want to shift and talk about common expert types in construction disputes. I would say I kind of break them into three categories. I know I have four listed here. But basically, I think of it honestly as oftentimes as schedulers, damages, and everything else. I did separately list out standard of care, and I'll explain why as I kind of discuss through these. We haven't done our Construction Law 101 session on scheduling and schedule claims, but that's coming. Scheduling claims, I would say, at least have been a plurality of my career, if not the majority of cases having at least some scheduling element. And obviously, if you're going to have a dispute about the schedule, chances are you're going to need a scheduling expert. So that's kind of the most common expert I think I've hired in my career. Damages might be actually tied with schedulers. Uh, it's when it comes to damages, it's very rare in my experience that you want your client testifying to the damages. If you have super straightforward damages, you might be able to get away with it. Um, I have one case that I can think of in my entire career where we preferred that approach and it was sufficient. Where we didn't hire a damages expert. Um, Generally speaking, the math is complicated enough that it falls under experts' jurisdiction, so to speak, or their expertise. Um, Clients will, I mean, even if you're helping them along a lot, there's just certain things they're going to miss, and a damages expert is, in most situations, worth it. All right. Um, And then, so next, that means you've got standard of care experts. Um, Standard of care is somewhat amorphous, but generally speaking, if a professional messed up, you're going to need, in my like practically speaking, an even better credentialed professional to say that the professional messed up. So if you're going to accuse an architect of doing something wrong, well, particularly in Georgia, you're going to need an expert to say so. But in an ideal world, you'll have an expert that has better credentials than the architect who screwed up, explaining what they did wrong, why it violated the applicable standard of care, and how it, in turn harmed your client. Um, You'll also need standard of care type experts when it's engineering malpractice or those sorts of things. And it's also kind of a shorthand for, in my mind at least, standard of care experts for someone who's going to say that someone generally did something wrong. Not that, and honestly, when you use that type of expert, this is something Wheaton will touch on a bit more. I think you run the risk of a Daubert challenge there, but oftentimes, particularly in arbitration, there's an expectation on big enough claims and big enough disputes that someone come in and offer a very I wouldn't say very, but oftentimes generalized opinion that the other side messed up. They submitted, way too many change orders or way too many RFIs on this project, and that violated the standard of care or the industry norms that would apply to a similar project in terms of size and scope and that sort of thing. I wouldn't go so far as to call it junk science when you're doing that. It's a part of a lot of construction disputes, but there's not necessarily an easy and obvious subject matter expertise that those types of standard of care experts have. And so when you're hiring those, I would suggest just proceeding with caution and make sure you really have someone who can speak to what the industry norms are and what was in fact violated. Otherwise, and again, it might depend on your jurisdiction if you're in court or not. Um, it's almost like piling on what the facts show and substituting the expert's judgment for the attorneys basically wanting to argue about what the facts show. All right. And then there's everything else. I think of this as your PhD types. Do you need a metallurgist for some reason? Do you need a civil engineer to talk about why a retaining wall failed? Do you need, a mechanical engineer to talk about some arcane art known as strip steering? That's something Wheaton and I have handled before, where we needed a strip steering expert. I didn't know what strip steering was until that case, but I learned a lot. So that's the kind of everything else category. And want to kind of shift. It's a good segue into selecting and working with experts, and just kind of the concept of uh, where do you find experts in the first place? And so most of you have probably already heard of all of these firms, and this is not meant to be an endorsement of any one firm or anything like that, but you've got places like BRG, Secretariat, FTI, Kroll, HKA, Ancura, Delta, Exponent, GlassRatner. Those were just the first couple I jotted down. There are a lot of firms, just like law firms, that where you can go and hire experts. The two most common that you will easily find at those types of places are your scheduling and damage experts. Um, if you think about it, the more obscure the expertise you need is, the less likely it's a viable business for someone to be a full-time expert in that field. There are obviously enough lawsuits that involve scheduling and damages issues that you have plenty of full-time scheduling and damages experts. Damages experts, you want to be cautious to a certain extent there because other lawyers need damages experts too. And you might want to specifically find one that has expertise in construction disputes as opposed to just a generic damages expert. You'll find both types. And in selecting your expert, want to just assess whether or not you need specific construction expertise in your damages expert, or if you're okay with someone who handles maybe all types of legal damages. It really just depends on your case. Um, Other places to find experts. And this again, this is going to be more when you're in the catch-all category that I said of everything else, your PhD types. There are firms like Exponent, at least for me, is the first one that comes to mind, where they have a lot of various people with PhDs that are going to have really maybe somewhat niche areas of expertise. When you need a high level civil engineer, metallurgist, that kind of thing, electrical engineer, that's one of the first places I think of when I need to find that type of person. Um, Another great resource in locating experts that you should consider is asking your client. They're in the line of work that potentially went wrong and might know of some of the industry professionals in that space. Um, and so that they're a great resource. Obviously, you can just poll your colleagues when you need to and ask, does anyone know of an expert in this certain area? Uh, you can just do your own research, obviously, and start searching the web for people with expertise in a certain area. Uh, One bit of advice is, just for particularly for the younger lawyers on this CLE, having a big network that you can tap into. You never know when you're going to need it, but man, when you need to hire an obscure expert and you have a lot of random people you can email who might be interested in helping you out, it can be a game changer in terms of who you find. So it's always nice to have a big network before you need it when it comes to finding an expert. Um, Another thing that exists, there are expert finding services. I have never personally used one. It strikes me as unlikely to lead to the best and most appropriate experts. But if you're ever stuck, I'm sure there are some good expert finding services that you could use. Another good place to find experts is university professors. Generally speaking, there you're going to find the expertise you need. The question is, do they even want to be an expert witness in the first place? Do they know anything about what the work entails? And are they going to be any good testifying? Those are things you can only determine based on reaching out to them. But you can usually figure out who I had to do this once where I figured out I needed an obscure section of the electrical engineering department. Each university had about one, maybe two people who actually taught the relevant course. And I just went through school after school, finding the people who taught that course at the respective school and had to email a bunch of professors until I found one who says, oh, yeah, I actually like serving as an expert witness and I have the knowledge. So university professors are a good resource when you're really diving into the technical weeds. Um, so that's just kind of some of the different places you're going to find all these experts. The next thing that you're probably all wondering about is what's Todd's 10% rule. This is generally true. That, in my opinion, when you interview an expert, which is generally the next step, once you get some names, obviously, you want to talk to them and see how they present. In my experience, experts are no more than 10% different from how they present in that initial interview to how they will present on the witness stand or in a deposition. Very rarely are people capable of just doing a complete about face in terms of being maybe somewhat lackadaisical in an interview and the sharpest person you've ever seen on the witness stand. There are exceptions to that rule. Hopefully, they work to your favor if you ever find yourself in that exception, because obviously it could go both ways. But, like, just as a simple example, if your expert has a hard time getting onto the Zoom and getting their camera to turn on and that kind of stuff, they're going to be a little technically challenged throughout the dispute. They might be difficult to work with in terms of sending them large files and things like that. That is what it is. If they present well enough, once you actually get to see them, that's generally speaking more of what matters. But in terms of selecting experts, I at this point firmly believe you get what you interview at the end of the day. Um, all right, so that's kind of selecting them. In terms of working with experts, the first big thing is what information do you share with them? And generally speaking, you want to, in my experience, rely on their expertise. If schedulers, obviously they're going to need the project schedules in native format. Damages experts, they're going to need a lot of financial documents. Some of that's pretty straightforward, but the best experts and experienced experts are all going to be able to tell you what they need, and then you can work with your clients to assemble that information and share that with them. Um, you know, every once in a while, you're going to need to silo experts off and have them only handle a certain area of the case, and then you might only give them certain information. And I would say, as a practical matter, um, you're generally speaking better on erring on the side of providing your expert more than they need, not less. The obvious consideration that you have to balance that against is cost. You have, as lawyers, we're generally responsible to our clients for making sure the expert manages their own budget and doesn't go too crazy on costs. But generally speaking, in my experience, you want to share with them more. The practical reason, in my experience, is your when your expert gets deposed, they're almost inevitably going to be asked at some point, did you have all the information you needed to form your expert opinion? And if the answer to that is ever no, your stomach is going to drop and you're going to try and keep a poker face during that deposition. But you never want your expert to say, I didn't have all the information. I only had what the attorney gave me. Um, the reason that's so problematic is kind of going back to what I mentioned at the beginning. It's a little bit of a facade we put on experts' independence, but if it's clear that you are only spoon feeding the documents that are good for your client, and specifically excluding from your expert's review certain documents, that's going to, in all likelihood, do way more harm than good. Your adversary is going to figure that out. They're going to say, well, if you had considered all this other evidence, could your opinion have been different? So it's, in my opinion, really important to share as much as possible with your experts. And it's kind of a good segue into the topic I wanted to talk about next, which is the concept of testifying versus consulting experts. Um, Generally speaking, consulting experts advise but do not testify. And absent exceptional circumstances, they are not disclosed to the other side. And then testifying experts generally submit written reports and are deposed or testify. They're kind of what everyone thinks as your expert. Um, the reason this kind of dichotomy exists is oftentimes the only way to hear the hard truths that your client might need to is via a consulting expert. If it actually becomes clear that, this say this structural failure was in fact your client's fault, and an expert's like telling you that, that's going to be information you would probably prefer to keep as confidential as possible. And that's where consulting experts come in. So sharing that information with your expert is really important. I think in ultimately getting to a good strategy for what has to happen on the case. Um, Testifying experts, again, they are what I think most young lawyers just think of as the expert witnesses that you hire. Um, but as I mentioned in the last bullet here, it is very common for consulting experts to be converted into testifying experts. Oftentimes they're hired as consulting experts, and then when your formal disclosure obligations come along, you designate them as your testifying expert, and voila, they're your expert, so to speak. There's not any sort of like formal rules around that distinction or how you manage it yourself. But obviously, there is a big body of case law that describes what is protected from disclosure when it's merely a consulting expert and not a testifying expert. Um, and which is kind of a good segue into my next topic, which is privilege considerations. I mentioned the old rule versus the current rule. The federal rules of civil procedure were amended somewhat majorly as it relates to experts in 2010. I mentioned that because for the younger lawyers, if you're practicing with an older lawyer who seems really, really conservative about what you share with an expert and that you only ever pick up the phone, it is probably because that older lawyer was raised in an environment before the 2010 amendments to the federal rules of civil procedure, and they are somewhat right to be more protective of what was shared with an expert under the old federal rules of civil procedure. Literally, draft reports used to be discoverable, and so there was any number of hoops parties would jump through to ensure that an expert's report would not be discoverable, and yet you would sort of know what was coming. Under the current federal rule of civil procedure, you don't have that concern really that your experts' draft reports are discoverable. Generally speaking, though, obviously, if you read the rule, it's somewhat straightforward in that the facts and data that you give your expert, the documents you give them, that sort of thing is discoverable. The conversations you have with your expert, again, I got to say, generally speaking, are not discoverable. There are exceptions. The exceptions are pretty rare when any conversation you have with your expert or something like that might somehow become discoverable. But just like I said, generally speaking, you're able to talk openly with your expert and share your thinking with your expert, get their thinking, their thoughts without it becoming discoverable. There are sometimes exceptional circumstances where that privilege can be pierced, essentially. Um, Again, it's important to consider in your arbitration scheduling order, given so much of what a construction litigator does is in arbitration, that you adequately cover experts. Most arbitration scheduling orders I've ever seen say basically mirror the federal rules that say, draft reports, any communications with an expert are protected from disclosure. That would probably be what would happen if their scheduling order is silent on the point, but there's no reason not to include it and just be certain that your communications and things shared with your expert are going to remain privileged in arbitration. All right, I'm almost coming up on the end of my 30 minutes, and I want to pass it on to Wheaton. I just wanted to mention at least two other points real quick that you should be aware of. Um, the first is the concept of a hybrid fact slash expert witness. At least that's how I think of them. Buried in Federal Rule of Civil Procedure. It's basically identified in terms of non-retained experts. This is a disclosure you will want to make if you want one of your clients' witnesses to basically offer opinion testimony. There's a disclosure obligation. They're not expected to author a full report, but it's very important to comply with that. If you have people with technical expertise and you want them to be able to speak openly about that technical expertise, otherwise, another side might make a completely valid and sustained objection to your fact witnesses testifying to something that you didn't give a lot of second thought to, that, oh, surely, this guy's our steel expert. He's going to be able to testify to the certifications and all these things that we did as a company. Well, he might be able to testify to the facts, but translating that into what it means or how it impacts the current dispute is hard unless you follow this subsection. Certificates of merit. Here in Georgia, to sue an architect, an engineer, you need a certificate of merit that basically says we've had another expert look at this and agree that it's worth bringing a professional malpractice claim. If you don't do that, the architect or engineer you're suing will be able to dismiss your lawsuit by not getting a certificate of merit. Please note that certificates of merit vary widely from state to state. In California, I once dealt with one. I can't even remember the details, but I do, and I apologize for that. But check your local state rules. In California, it was almost like the opposite of Georgia. You needed an expert and a certificate of merit, but the detail that was required of it couldn't have been more different from bringing a lawsuit here in Georgia. And I know this is probably the worst of all of my segues today, but I am going to just mention it nonetheless. I have never seen a Daubert challenge in arbitration. That doesn't mean they don't exist. I could imagine a scenario where you would want to bring one because the other side's expert is just so far afield from what matters. But anyway, so with that glowing endorsement, I'm going to leave it to Wheaton to talk about Daubert challenges where they do actually exist, which is in federal and state court.
Thanks, Todd. Now that you've told everybody who primarily is in arbitration that this is irrelevant to them, I suspect a fair number of folks are going to be dropping off. So thanks for that, Todd.
Yeah.
No, I think Todd is right about Daubert challenges being rare in arbitration. I think they are similarly rare, probably not to the same degree, but I think they're rarer in cases that are going to be tried before a judge. And that's because one of the policies underlying Daubert, and we're going to talk about this a little bit more, is that the court is serving this gatekeeping function of keeping sort of unreliable or untrustworthy evidence from getting to a jury who apparently some of the judiciary believe might be easily duped. But if you have an arbitrator who has already seen the testimony, by way of a Daubert challenge, and the same is true of a judge in a bench trial, then that sort of policy underlying Daubert is out the window. The judge has already seen the testimony, so there's nothing to protect them from, and they'll have formed their own opinion about its merits by then. But like Todd said, this is Construction Law 101, so we're going to start at the very basics, particularly for the new folks on the call. What is a Daubert challenge? At its core, a Daubert challenge is a way to exclude evidence, expert opinions, and testimony under Federal Rule of Evidence 702. It comes out of the case of Daubert versus Merrill Dow Pharmaceuticals Incorporated. It's a Supreme Court case that rejected a prior standard for assessing expert testimony, or at least modified it. Again, we'll talk about this a little bit more later on, but that prior standard was called the Frye standard, and some states still apply that standard. It's a little bit different from Daubert and some of the things that it's focused on, but really at its core, a Daubert challenge is brought through a motion, and the idea is some of this testimony doesn't meet the core requirements of Rule 702, and so it should be excluded. So it's essentially a request for a ruling on an evidentiary issue. So under Rule 702, expert testimony is admissible if the witness is qualified, if the testimony or the opinions is helpful to the jury, if it's based on sufficient facts and data, and it's rooted in a reliable methodology, and the expert reliably applied that methodology. So each of these requirements can form the basis of a different type of Daubert challenge that you might find yourself either defending against or filing. You can challenge an expert's qualifications. You can challenge the value of the testimony in terms of helping the trier of fact. You can argue, and we have argued, that it's not based on sufficient facts or information. That gets to the point that Todd raised earlier. If you have an expert who said, well, I requested these documents, but I didn't get to see them, that would raise a significant red flag about whether they had sufficient facts and data. If I'm in that deposition, I want to probe some more and ask about why they were requesting those particular documents, and whether it was essential for them to perform their analysis and form the opinions that they formed. So that's why, one, if you're deposing an expert, you want to ask that question, and two, why you want to make sure you've given your expert everything they need, because otherwise it provides a pretty good fodder for a Daubert motion. And then the final point there about a reliable methodology and reliable application. This is where, in my experience, I've seen most Daubert fights happen, about whether a particular type of methodology is reliable, and whether the expert has sort of performed that methodology the right way. I see that. I think that would probably be somewhat less common with like a scheduler, but certainly, it's plausible. I think most of the cases that I've seen that involve like a causation expert who hasn't really considered sort of all the potential scenarios that they're opining on. So Todd, we can move to the next slide. All right. So again, for the new folks out there, why would you want to do a Daubert challenge? Well, the most obvious is that you can use it as a way to exclude damaging expert testimony. If you are, particularly if you're the defendant or the respondent in a case, if the other side has testimony that is damaging to your client and it's advancing the other side's claim, then it would be helpful if it wasn't there anymore, right? So the idea here is, it's a way to exclude testimony that's not helpful for you. That said, just because opposing counsel wants it to be included doesn't necessarily mean you want to move to exclude it. Todd and I have had cases together where the expert witness, we ultimately made the determination that they were that some of the positions they were taking were so incredible that we wanted to be able to cross-examine them. And the answers we anticipated getting at trial would have advanced our case thing. So even though we had a valid basis, we would have had a strong Daubert motion. We made the decision to not challenge the expert because we thought we would be better off if we had an opportunity to depose the expert and show how the things that they were saying in the case were really just a continuation of some of the things we were trying to prove. Another one of the great uses, and I think this is probably the most powerful way to use a Daubert motion, is by combining it with a motion for summary judgment. I've included a site here, Lowry v. Santa Fe Avantis LLC. This was a case in the Northern District of Alabama, and I think it demonstrates the way that you can pair a Daubert motion and a motion for summary judgment in a really powerful way. So in that case, there was a motion for summary judgment on a pretty technical issue of federal preemption that, in my opinion, likely would have been appealed. So there's an adverse decision for the plaintiff on that. So there's a finding that whatever their claims were, they were preempted by federal law. I think that the plaintiff likely would have appealed that issue because it was a rather complex, thorny issue that I think they probably would have had a reason to want the 11th Circuit to weigh in on. The problem for them, though, is it was paired with a Daubert motion to exclude another, or rather, one of the expert witnesses' testimony. In that case, it was that the expert was sort of opining, sort of a generalist in a certain field, but was opining on a very specific area. And so there's a challenge that he did not have the qualifications to provide testimonies and testimony at that level of specialization. So the court granted the motion for summary judgment on the preemption issue, and then it granted the Daubert motion and essentially found that the plaintiff didn't have one of the essential experts that it needed to establish causation in its case as a result. So now you have a motion for summary judgment with a thorny legal issue that can be appealed de novo, but then you have a ruling on a Daubert issue that they have essentially failed to create, a factual question on the issue of causation. But because it's an evidentiary ruling, it's within the court's discretion, and it would be therefore reviewed by the 11th Circuit under an abuse of discretion standard. So what that means is that ruling could have been appealed, but it very much would have been an uphill battle because of the Daubert ruling that was made in conjunction with the motion for summary judgment. Essentially, even if there had been a reversal on the preemption issue, a reversal on the Daubert issue, unlikely given the high appellate review standard, unlikely, and it would have resulted in the same thing, summary judgment for the defendant. So I think that's one of the most compelling and powerful ways to use Daubert. It also makes Daubert a little bit of a scary motion if you're on the claimant side of things, because it can derail your case very quickly, and it can make it hard for you to have really the same level of substantive review you would have on another legal issue. The final use for Daubert is that it can be great for settlement leverage for all of those reasons. At some point, the other side will be doing this calculus about what happens if the Daubert motion is granted and one of their experts is excluded. What does that do to their case? Well, it's really hard to overcome getting your expert testimony thrown out. It's not like other motions to exclude where you could probably figure out a way to use another one of your witnesses to get, a certain piece of evidence or a certain piece of testimony admitted. If your expert is thrown out, you're very likely not going to have another option. If you felt the need to retain the expert in the first place, it means they have specialized knowledge, and so you're going to, they're really essential to the case. If that gets thrown out, well, then their case goes away in a lot of instances, and so it can be a more powerful tool for creating settlement leverage than some of the other motions that you might file around the same time, like a motion in limine or something like that. Right. So let's talk about some of the different types of Daubert challenges you might see. I referenced this at the beginning, but reliability challenges, these I would say in my experience are probably the most common type. These are based on the requirement that the expert, you apply a reliable methodology and that they have applied that methodology reliably. So there's actually two components to that. It's that the methodology itself is reliable, which is more of a factual question, and that the expert has used that methodology or applied that methodology the right way. Some of the factors when you're doing that first type of challenge about whether the methodology is itself reliable, these are in Daubert, in the Daubert case itself. Whether the methodology can be tested or has been tested, whether it's peer-reviewed, whether it's been published, if there's a known error rate, and if it's generally accepted in the community. Any one of those factors, you would be sort of arguing over if you're challenging the reliability of a particular methodology. Again, I think with a lot of the sort of standard experts that you might see in a case, in a typical construction case, you probably aren't fighting over reliability as much. It's more so over how the whether the methodology is self-reliable. You're more likely to be fighting over whether the expert has reliably applied the methodology. Um, the other category of experts, the fourth category that Todd mentioned, I think that's where you open up the door to a lot more questions about how they reach their conclusions and whether whatever methodology they're using is really reliable. Important note: these factors are not dispositive. There's a question about this for a few years after Daubert was decided. Like how much weight do we have to give these factors? There's another case, Kumho-Tyer, decided by the U.S. Supreme Court shortly after Daubert, and it allowed for a less rigid approach to some of the expert issues that came up. And it opened the door for things like experience-based testimony, which would be like some of those folks that Todd referenced who are testifying about standard of care, saying, I've been in this industry for 35 years and I've never seen somebody do it that way. That's not really, a methodology from like a scientific method type perspective, which is what Daubert was sort of concerned with when it was decided. But that category of testimony that's more experience-based, or it's more educating the court or the jury, the arbitrator, whoever, about some of the factual or technical issues, is admissible, even if it's not based on like a really easily discernible methodology. One practice tip that I use when I'm working with an expert is try to get them to label whatever it is that they're doing in terms of a methodology. And that will give you a little bit of cover if you have a reliability challenge, because I've seen opposing counsel before say, well, the expert doesn't identify a particular methodology. They don't claim to have applied a particular methodology. And they'll argue that as a basis for, excluding under Daubert. I think that's probably the wrong approach, given Kumho-Tyer and some of the options that opened up in terms of expert testimony. But nevertheless, if your expert is doing something and you that seems like it's maybe the scientific method or something that there is some rhyme or reason to it beyond this is just how I've seen this done, then work with them to see if you can get them to apply a methodology or put terminology to it. So just as one example, I was working with an expert that was offering causation testimony about why something was operating the way it was operating. And if you asked him, he would say, well, I've been doing this for a very long time, and I can look at this and tell you that, this is the problem just by looking at it. It was so obvious to him, but that's not going to cut it under the Daubert standard. And so after I talked with him a little bit about, really what his thought process was, he told me, well, he identified all these potential causes that could be contributing to the operational issues that they were experiencing that he was trying to resolve. And then he went through sort of systematically and excluded each of those causes until he was left with this one cause, and that was his opinion that it wasn't working for this particular reason. And he called himself a troubleshooting consultant. And so we called his methodology a troubleshooting methodology, and that worked out well. That worked for us. What he was really doing, other cases would call that a differential diagnosis methodology. That's sort of the way that's described in a lot of the medical cases, even some of the non-medical cases where they're focused on causation. But the point is, if you can get your expert to label whatever it is that they're doing, that will be helpful in terms of helping prevent some of those challenges to the reliability of their methodology. One word of caution, though. I mean, if you are fighting over whether a particular methodology is reliable, you have the Daubert factors that'll be a good guide for you about what to focus on. But there is a tendency I've seen on the part of some courts to just look at this and say, look, if we're fighting over, who is applying the right methodology or the right way to go about doing this methodology. This really looks like a factual issue, and you should just fight it out on cross-examination. So if your primary Daubert argument is that methodology isn't reliable, I think you need to do a hard look and really assess it under these Daubert factors and make sure that it's not properly characterized as experience-based testimony or something like that. Because I think courts have a tendency to view those types of challenges more as factual issues for the jury to resolve. And then you spent a lot of time and money preparing this challenge that's not ultimately successful. Some other types of challenges that you'll see: lack of qualifications. In my experience, these are somewhat rare. If somebody has a master's or a PhD, it's unlikely that they're going to get excluded because they don't have the postdoctoral fellowship or something like that. So those sorts of challenges, I don't see those very often. I think they're pretty rare, and I'm not sure. I think they would probably be unsuccessful. I think a court would be inclined to say that's just a matter for cross-examination. You can point to the fact that your expert has done a postdoctoral fellowship and has published all these articles, and the fact that the other expert's only done a master's, and let the jury decide about whether that's really material. The one area where you might actually get some traction in these is when you have a generalist testifying on an area that's highly specialized, or if you have somebody testifying outside of their engineering expertise. So I have the example of a civil engineer testifying on an electrical engineering topic. There may be a scenario where that would be appropriate, but when you're selecting your expert, you want to get them as close to whatever the topic is that you are dealing with or that you need their opinion on, rather than focusing on a generalist, because that can raise questions about whether they're qualified. Lack of sufficient data, information. Again, if they've admitted in cross-examination that they needed these documents, they didn't have them, then that's a strong basis for an argument based on lack of data or information. Again, this is a little bit like fighting over whether a particular methodology is reliable. If you have one expert that says, well, they needed to perform 100 tests to have a level of confidence here to offer these opinions, and the other expert says, well, no, I only actually needed to perform 20 tests. Now the judge is sort of weighing that expert testimony and trying to figure out who's right. And in my experience, courts are pretty reluctant to wade into that sort of a battle, and much more likely to just say the jury can figure out whether 100 tests is better or 20 tests is better, or whether 20 tests is even enough in the first place. Final category of challenge you might see is these are opinions that are unhelpful for the jury. So legal conclusions. If you have somebody testifying on a standard of care issue and their testimony goes beyond this is the standard of care and this is how they didn't meet it. If they take the next step and say, and therefore they were negligent, I would want to get an order from the court saying that opinion that therefore they were negligent is not admissible. And I think you would have a strong basis for excluding that under Rule 702 because it's a legal conclusion. It's therefore not helpful to the trier of fact. And then matters not in dispute. I don't see these too terribly often, but if you have an expert who is either sort of beating a dead horse from some other bit of testimony or trying to get in testimony that a party might not otherwise be able to get in for admissibility reasons or issues with witness availability, then those would be the sorts of things that are unhelpful and improper. So a lot of times just on these, you'll see courts talking about the expert can't parrot the testimony of others, or they can't be a conduit of opinions from others. So if you have an expert who comes in and says, yes, I reviewed all the findings from the in-house experts at XYZ company, and they're all correct, that testimony would be inadmissible under Daubert because it's just acting as a way to get in testimony of others under the auspices of an expert's credentials. Next slide. All right. Todd touched on this a little bit, so I won't spend a whole lot of time on it. But when you're thinking there might be a Daubert challenge, your strategy really needs to begin prior to your expert depositions. You need to be thinking about what your expert is saying about their case. Work with them to identify some weak points, any areas where if they're applying a methodology that your expert is familiar with, make sure that they've done every step of that process. I've had cases where an expert has said, I'm applying this particular methodology for computing the present value of certain damages instead of this other methodology because it's not appropriate under the circumstances. And then they applied the methodology that they said they weren't going to apply because it wasn't appropriate. And if you have an expert that you're working with who can identify those sorts of deficiencies, they'll be able to pick up those sorts of inconsistencies a lot more easily than you will be able to. And the final issue I think is super important. Review cases where courts have excluded the type of expert at issue. This will give you a good framework for understanding the types of issues that the courts are looking at, things that you should be asking in the deposition, lines of questioning that you might want to pursue, start laying the groundwork for some of those challenges. So the procedure for a Daubert motion, these are, in my experience, always, but I'm sure there's an exception, but pretty much always filed at the close of discovery. Whoever is the proponent of the testimony, so the party who's retained the expert and is advancing their testimony, they have the burden of proving that the testimony is admissible under Rule 702. So when you're drafting your motion, that's an important point, is that, if there's an area where they haven't, where there's sort of a question mark, then it'll shift the burden or point out the burden on the other side to fill in the gaps there. And that can be done at a Daubert hearing or in subsequent responsive affidavits. But it's important as you're framing that motion to remember that the other side, even though you're the movement, the other side actually has the burden of proof that the testimony is admissible. Responsive affidavits, if your expert has been Dauberted and you think there's either been a mischaracterization of their testimony or there's a challenge on an issue where the record just doesn't exist, then you can submit a clarifying affidavit from your expert. This is a little bit of a gray area, though, because your expert can't offer new opinions. They can't change their opinions or modify their opinions. So if you do an expert affidavit in response to a Daubert motion, you'll probably end up fighting about whether that affidavit was appropriate and whether it sort of exceeded those limits. But as a general rule, I mean, if it's a question about they didn't provide evidence of the expert's qualifications, I think that would be an unlikely challenge in the first place. But if that's what it is, then your expert can include an affidavit in the response that says, here's my resume, here's all the experience that I have, and here's why that makes sense in the context of these opinions. And then if worse comes to worse, you can always ask the court to hold a Daubert hearing where your expert will go up on the stand. You'll have an opportunity to do a direct examination, a cross-examination, and fill in maybe some of those gaps that are existing in the record. Or if the court really needs to understand what some of the issues are, a Daubert hearing can be useful for that as well. A couple limits on Daubert. Obviously, it can be a very useful tool for excluding testimony like we discussed. It can help with the motion for summary judgment. These motions do have some limits, though. Judicial discretion, which we discussed. This is an evidentiary ruling at the end of the day. And so judges' preferences are really going to matter. We've had judges, Todd and I, in cases we've worked on, where the judge will say, I I just don't think Daubert makes a whole lot of sense. And it's, you say one thing, their expert says another thing, and we'll just let the jury decide. Um, that was said in a federal court in a pretrial conference, and notwithstanding all of these cases that say that the court has a duty to gatekeep these experts and a duty to do a fulsome analysis of the issues. At the end of the day, it's an evidentiary ruling, and so there's very little we could have done if the judge had just said everything comes in, even though we had I think strong Daubert motions in that case. The other escape hatch that you see judges use a lot is that this or that issue is just something that should be covered on cross-examination. Um, I don't know that anybody has a clear understanding of where that line is, where it's a reliability issue versus a cross-examination issue. But you'll see judges throw that out a lot, I think, when they're just wrestling with something that doesn't maybe feel like it should be excluded. But it doesn't seem like there's any real rhyme or reason to it in my experience. So Daubert in Georgia, so in Georgia state courts, very similar to the federal standard. Georgia's rule of evidence is based on the same Rule 702 from the federal rules. The Georgia Supreme Court, they never sort of came out and officially said we're adopting Daubert like some other state Supreme Courts did. But what they did was in this Mason versus Home Depot USA Incorporated case, they basically said the updated version of Georgia's Rule 702 is the same as the federal rule. And for that reason, we can look to Daubert and Daubert cases. And ever since then, they've sort of applied the Daubert standard without expressly saying that's what they're doing. One final expert-specific rule for Georgia, 702C, requirements for malpractice actions. Whoever your expert is has to be licensed at the time of the alleged act or omission. This is certainly easy to satisfy because that you're effectively looking for somebody who has done something, who became licensed within the statute of limitations, and that shouldn't be hard to satisfy. Certainly, if you're looking for somebody with relevant and reliable, experience. But it's also easy to overlook, and if you don't meet it, that would be a very easy basis to get some testimony excluded. So that's just one Georgia-specific nuance.
That's a great point. I will say there is a very bizarre case out there where the court effectively was going to need a 107-year-old expert or some. I did the math. I wrote an article about it a while back, but basically it was an allegation that a roadway was designed wrong, and the intersection was designed so long ago there was basically no civil engineer alive who could have provided the requisite expert opinion necessary. So there is at least that weird quirk that has happened with this rule. So unlikely to happen again, but you never know.
That is a great outlier case, Todd. I like that.
Anyway, all right. That covers it for today. If anyone has any questions about anything we said, feel free to email us, and thank you for attending.